My name is Jonathan Goldsmith, and I work with the European Lawyers Foundation and will be the moderator for today's session. Before we begin, there are a few announcements to make as follows. So the title of the webinar is Whistleblowing, Exploring the Role of Lawyers in Relation to Whistleblowing in the European Union. We're expecting a big crowd this morning. Some are still being let in, and so that's why we'll have these announcements while everybody is settling in. We encourage the use of questions during this webinar. So we would like it to be as interactive as possible. Obviously, there will be presentations by great experts, but please put your questions. You will see at the bottom of your screen in the middle, there is a question and answer box. Please put your questions in the question and answer box and they will be answered. Please do not put questions in the chat. The chat is for you to say, hello, I'm from wherever you're from, and to let us know that you're there. We like that. That's for the chat. But for questions and answers, please put them in the question and answer box. We'll try to answer all the questions, but we have over 500 registrations, and so some questions may go on unanswered. Just to let you know, this webinar will be recorded. It will be in English without interpretation. We do not provide certificates for this training. We will send the list of participants and the time that you have been connected to those bars who ask us for the list in terms of recognition of the training that you're undertaking today. So please ask your bar if it will recognize this training, as we ourselves will not issue the certificates. You will see we have some very good slides. They will be available on the European Lawyers Foundation website, plus a link to the recording in a few days' time. So you will have access to the slides. And now I'd like to call on our opening speaker, Dominique Attias, to make a few welcoming remarks. Dominique Attias is the chair of the European Lawyers Foundation Board of Directors. She was vice president of the Paris Bar, and she's immediate past president of the FBE, the Federation of European Bars. Dominique, over to you.
Thank you very much. Dear colleagues, it's a pleasure for me to welcome lawyers from across the European Union and beyond to this webinar. And Jonathan told you the title, it's Exploring the Role of Lawyers in Relation to Whistleblowing in the EU. Today's event is part of a series of webinars that European Lawyers Foundation has organized in 2022 on issues of relevance for lawyers. After two webinars dealing with the legal aspects on the situation that followed the Russian invasion of Ukraine, we hold a webinar on surveillance and the impact of modern spyware on fundamental rights. These webinars were organized in collaboration with the Council of Bars and Law Societies of Europe, the organization that represent EU bars and law societies through its members, and that represent over 1 million of European lawyers. Today, we hold the last webinar of 2022 on a very relevant topic as whistleblowing. I'm delighted to introduce this webinar, which is organized in collaboration with the European Center for Whistleblower Rights. Whistleblowing is a very important topic for EU lawyers, especially since the European Commission adopted in 2018 a package of measures to strengthen whistleblowers' protection as a means to unveil unlawful activities and help enforce EU law. Indeed, today, our superb experts will tell us about the importance of the EU legislation in this field, on the role of EU lawyers on whistleblowing, and on successful strategies and on limiting risks to whistleblowers. I hope this webinar will be useful for all the participants that are taking part in today's webinar, and that you enjoy the event as much as we did in preparing it. I wish you a very successful webinar. Thank you very much.
Thank you very much, Dominique. And now we move into our first substantive session. The first substantive session is advertised in the program as Key Legal Provisions, Principles and Concepts, including the 2019 EU Directive and selected national laws in Europe. Principally, our speaker, who is a great expert, Dr. Lauren Kierans, will be speaking about the 2019 directive, which really sets the framework at European level. Dr. Kierans is a barrister and assistant professor in law at Maynooth University in Ireland, where she lectures on whistleblowing law at undergraduate level, as well as delivering a professional certificate on whistleblowing law, practice and policy. She's a co-founder and director of education at the European Whistleblowing Institute, and in fact, she was awarded her PhD on the Irish Protected Disclosures Act. So she is a great expert. She's published articles and book chapters on it. She's a founder of the Irish Whistleblowing Law Society, and she has a book coming out, Whistleblowing and the Protected Disclosures Act in Ireland, next year. Lauren, your CV is longer than that as well, but we'd spend all our time talking about that. So please, will you take over and take us through your slides? Thank you.
Thank you very much, Jonathan, and thank you for that kind introduction, and also to the European Lawyers Foundation for inviting me here today to speak on the EU Whistleblowing Directive. I propose to share my slides for my presentation this morning. Excuse me.
That's it.
Okay.
They're there.
You can see, brilliant. Thank you very much, Jonathan. So I am delighted to talk to you this morning about the EU Whistleblowing Directive. 30 minutes is not enough time to go through in detail the key provisions of the directive, but I propose to give you an overview of the main provisions. I do have a lot of slides for this morning's presentation. I may have to gloss over one or two of them because of time, but you will have access to a copy of these slides post-presentation. So the EU Whistleblowing Directive stemmed really from a realization that very few people across Europe either knew where to blow the whistle or also had fear in respect of retaliation. And a 2017 survey by the European Commission found that 49% of citizens across the EU did not know where to report corruption, and only 15% knew about existing rules on whistleblower protection. And it also transpired from that survey that it was mainly the fear of retaliation in respect of legal consequences and financial consequences that discouraged individuals from speaking up. And the value of whistleblowing really cannot be understated. There's data internationally demonstrating the value of whistleblowing. And in fact, if I refer for example, to two sources of data. One, a study conducted by KPMG in 2016, where it looked at 750 incidences of fraud between March 2013 and August 2015. And it uncovered that 44% of fraudsters were detected as a result of a tip, complaint, or formal whistleblowing hotline. Indeed, this data is replicated in the report by the Association of Certified Fraud Examiners that looked at over 2,000 cases of real occupational fraud from 133 countries and in 23 industry categories. And again, it was identified that tips was by far the most common initial detection method, with 42% of occupational fraud being detected by means of a tip. And this was over 3 times more than the next common detection method, which was internal audit at 16%. And further, those tips, 55% of those came from employees. So in recognition of the fear of for people for speaking up about wrongdoing across the EU and the value of whistleblowing, the EU adopted in October 2019 the Directive on the Protection of Persons who Report Breaches of EU Law. The intention behind this directive was to lay down minimum standards for protection of whistleblowers. And the European Commission had identified that at the time there were only 10 EU member states, and this included the UK, that had comprehensive whistleblower protection. And there were a number of member states that had only partial protection, in that there was only legislative protection for certain industries or certain workers, or in respect of certain forms of wrongdoing. So the directive was designed, and it's set out in Article 1, to enhance the enforcement of union law and policies in specific areas by laying down common minimum standards, providing for a high level of protection of persons reporting breaches of union law. Member states had to transpose the directive into national law by the 17th of December last year. But in fact, as of October, only 10 EU member states had transposition laws. And further, 12 had transposition bills. But no country can, in fact, have been held to have transposed completely the directive, and the European Commission has instigated infringement proceedings against 26 member states. So the directive itself is designed, as I've said, to provide protection to individuals who blow the whistle on breaches of EU law. And what's necessary in order for such individuals to be protected is that they must disclose information on breaches. And this is defined under the directive as being information including reasonable suspicions about actual or potential breaches which occurred or are very likely to occur in the organisation in which the reporting person works or has worked, or in another organisation with which the reporting person is or was in contact through his or her work, and about attempts to conceal such breaches. Now, this very much underpins the fact that this directive is in respect of workplace whistleblowing. And it does provide protection to reporting persons about breaches. And we're going to look further at who are reporting persons and what are considered to be breaches. But in order to attract the protections, the reporting person must meet a minimum threshold. That being that they must have reasonable grounds to believe that the information on breaches reported was true at the time of reporting, and that such information fell within the scope of the directive, and further that the reporting person had reported either internally or externally or made a public disclosure. So in this regard, when we're looking at what is being disclosed by the reporting person, we will see that knowingly false disclosures are not protected, but those that are based on reasonable grounds will be protected. But further, the reporting person must disclose through the designated channels, those being internal, external, or public. And again, I will bring you through that in more detail momentarily. Now, in respect of the personal scope of the directive, it is extremely broad. So we're not just talking about employees in the public and private sector who can make a disclosure or a report, but we're looking at workers, including former workers, civil servants, those who are self-employed. It even goes as far as providing protection to shareholders, to those belonging to the administrative, management, or supervisory body of an undertaking, including non-executive members, volunteers, paid or unpaid trainees, contractors, subcontractors, suppliers, persons in a recruitment process or other pre-contractual negotiations. So if an individual acquires information about a breach in a recruitment process or other pre-contractual negotiation and they disclose that, they will also still be protected. In addition, there are protections for facilitators, so those who assist and facilitate other reporting persons in making their disclosure. Third parties who are connected with the reporting person and who could suffer retaliation in a work-related context. So this, for example, provides protection to colleagues or family members of the reporting person who suffer harm because a reporting person had made a report of a breach. And in addition, legal entities that the reporting person owns, works, or otherwise connected with in a work-related context. So again, we're looking at an extremely broad scope of protection for individuals. And what's necessary is that they must make a disclosure of a breach of union law or areas that defeat the object or purpose of the rules of the Union Acts. And in this regard, what may arise in certain member states is, such as has occurred in Ireland, where we have had a whistleblowing law since 2014 that covered breaches of national law. The directive is only relating to matters of EU competence, but there may be legislation introduced that will cover both the national and EU breaches. So that is what has occurred in Ireland, for example. But the material scope is in respect of 12 policy fields, which I have set out here on the slide. So this covers, for example, transport safety, public health, consumer protection, and it goes on to cover breaches affecting financial interests of the union and breaches relating to the internal market. But as I've said, member states have the power under the directive to extend protection under national law to other areas. Now, in order for the report to be protected, it isn't enough that the reporting person falls within the personal scope and the material scope. They must also comply with the obligations around to whom the disclosure can be made. And the directive provides for alternative disclosure recipients other than the employer. It doesn't mandate that disclosures must be made internally. There are alternative recipients such as external reporting channels, such as competent authorities, which we'll look at in a moment. And further, there may be public disclosures provided for under Article 15. But in order to attract protection, there are a range of additional criteria that must be satisfied in making a public disclosure. Now, in respect of an external disclosure, this does permit member states to establish competent authorities for receipt of disclosures. And recital 64 to the directive explains who these competent authorities may be, and it can consist of judicial authorities, regulatory or supervisory bodies, authorities of a more general competence at a central level within member states, law enforcement agencies, anti-corruption bodies, and ombudsmen. Now, what's necessary is that member states must designate these competent authorities and ensure that they are properly resourced for dealing with whistleblowing. Now, again, by way of example, the approach adopted in Ireland is that we have adopted what's known as a prescribed person system. Now, this existed under our 2014 legislation and was modelled on the UK prescribed person system. And this consists of 110 regulators who are designated as competent authorities to receive disclosures because of their regulatory powers. Now, I will come back to discuss the obligations on these competent authorities. But before I do so, just again to flag to you the additional criteria for protection for workers or reporting persons who make public disclosures. So again, as I've emphasized, there are additional criteria for protection. For disclosures to through an internal channel or an external channel, all that has to be satisfied is that basic test of information on breaches that I took you through at the outset. But for a public disclosure, these are permitted, but as you see on the slide here, there are additional criteria. So for example, the reporting person had reported internally or externally first, or directly externally, but no appropriate action was taken in response to the report within the designated time frame. And again, we'll see in a moment that there are specific timeframes under the legislation for feedback to be given to the reporting person when they have used internal channels or external channels for their report. But in addition, for protection, the person must have reasonable grounds to believe that the breach may constitute an imminent or manifest danger to the public interest. So, for example, if there is an emergency situation or a risk of irreversible damage, or if they had gone external initially, there was a risk of retaliation, or if they had gone externally, there was a risk of retaliation, or there was a low prospect of the breach being effectively addressed in certain situations. Now, I'm going to address the obligations in respect of establishing internal and external reporting channels. But before I do so, I want to flag to you some key definitions under the directive, because I will be referring to these terms. So firstly, a report or to report is defined as meaning oral or written communication of information on breaches. Feedback is defined as the provision to the reporting person of information on the action envisaged or taken as follow-up and the grounds for such follow-up. And further, follow-up means any action taken by the recipient of a report to assess the accuracy of the allegations made in the report and, where relevant, to address the breach reported, including through actions such as internal inquiry and investigation, prosecution, and action for recovery of funds or the closure of the procedure. So these terms are important because, first of all, there seems to be a misconception that feedback requires an information on the timeframes for feedback has been misconceived as being a time frame for concluding the investigation, and that's not the case. We'll see that when it comes to timeframes for provision of feedback, be it 3 months, or for competent authorities maybe up to 6 months, that this then is only requiring providing the reporting person in respect of information on the action envisaged or taken, but it doesn't mean that there has to be conclusion of an investigation. And further, in respect of follow-up, again, there seems to be a misconception that that means that there has to be an investigation or inquiry of some nature into the report. But again, that's not the case. It means that the disclosure needs to be assessed to ascertain whether this is something that can be addressed by way of inquiry, investigation, prosecution, or whatnot. So again, these terms are very important to have an awareness of. Now, in respect of the obligation to establish internal reporting channels, this arises under Article 8 of the directive. And what's necessary is that organizations now of over 50 workers or reporting persons will have to establish, maintain, and operate channels and procedures for internal reporting. Now, that threshold of 50 workers doesn't apply if the entity falls within parts 1B and 2 of the annex to the directive. So, for example, if the legal entity is in the area of financial services, products and markets, prevention of money laundering and terrorist financing, transport safety, and certain forms of protection of the environment. Now, member states can include an obligation on organizations of less than 50 workers to have internal procedures, but this will have to be a subject to a risk assessment and notification to the EU Commission. Now, if the legal entity falls within 50 to 249 workers, there is a derogation where the obligation to have internal reporting channels doesn't apply until the 17th of December 2023. Further, if the organization has between 50 and 249 workers, then those organizations are entitled to share resources regarding the receipt and any investigation into the breach. Now, very briefly, again, there are a number of conditions attached to what must be included in the disclosure channels. But just by way of summary, what's necessary for the internal reporting channels is that there must be the designation of an impartial person or department for dealing or handling the disclosures, but this can also be provided by a third party, so externally by a third party. But the obligations in respect of feedback and communication and protecting the identity of the reporting person, it still applies to the organization itself, even if the procedures are operated by an external third party. Now, under Article 9 of the directive, what's necessary for the report to be made is that it must be permitted to be made in writing or orally or both. And we'll see, in contrast to external reporting channels where it must be permitted to be made in writing and orally, we see that it's more limited here, where there can be just a disclosure in writing or orally or both. Now, if the disclosure is made orally, that must be permitted by way of a telephone or through another voice messaging system, or the reporting person must be able to request a physical meeting, and that must be permitted within a reasonable time frame. Now, the reporting channels must be secure, so they must be designed, established, and operated so that they ensure the confidentiality of the reporting person and any third party who is mentioned in the report. In addition, the report must be acknowledged within 7 days of its receipt. And as I've said, the timeframes in respect of feedback is that feedback must be given within a reasonable timeframe, and this is a maximum of 3 months from the date of the acknowledgement of the receipt of the disclosure or the report, or if no acknowledgement was made at the expiration of that 7-day period. And further, there must be diligent follow-up. Now, the designated person or department must be competent for following up on the report. And that designated person or department can be the same one who receives the disclosure. So you may have the same person receiving and handling the disclosure. And for also that person or department must be in a position to be able to communicate with the reporting person and request further information if necessary. Now, as respect of the external reporting channels, there is some similarity as regards establishment, but also there are a number of differences. So first of all, again, the channels must be independent and autonomous, and it must enable the report to be made in writing and orally. Now, as regards acknowledging receipt of the report, this must be done within 7 days unless the reporting person explicitly requests that it's not acknowledged, or the competent authority reasonably believes that acknowledging receipt of the report would jeopardize the protection of the reporting person. They are required also to diligently follow up, and they must provide feedback within a reasonable time frame. However, that time frame must not exceed 3 months or 6 months in duly justified cases. They must further communicate the final outcome of the investigation to the reporting person. Now, if the report is determined by the competent authority to be minor, they can prioritize more serious reports. And further, if there are repetitive reports received with no information, then that report can be closed.
Just a few minutes left, Lauren, if you could wind up another 3 minutes.
3 minutes, lovely. Thank you very much. So I just want to address just some final issues in respect of, firstly, anonymous disclosures. Member states can decide whether or not anonymous disclosures are permitted under their legislation. In Ireland, the approach has been that if the disclosure is made internally, there's no obligation on the organisation to accept the disclosure and to follow up on it unless they believe it is suitable to do so. Whilst our prescribed persons or external channels, they must treat anonymous disclosures as if it was made as an identified disclosure. And further, there is under Article 6, however, the provision that if a disclosure is made anonymously, but the person is subsequently identified and retaliated against, they may avail of protections under the Act. As regards confidential disclosures, there are obligations to protect the identity of the reporting person, and you must not disclose any identifying information, either indirectly or directly, unless it is to an authorised person. And there are some exceptions around when the identity can be disclosed, but the individual must be informed in writing before any identifying information is disclosed. Protection clearly is fundamental to any whistleblowing legislation. It encourages workers to report, or reporting persons to report on breaches in confidence that they will not be retaliated against, or if they are, they can avail of certain remedies. So the list of what constitutes retaliation under the directive is extremely broad, and you can see that I've set them out here on the slide. Again, you can look at that in your own time. But the measures for protection is that it go further. There are also immunities under the directive in respect of any breaches of law in disclosing the report itself. And there are immunities, for example, around breaches of trade secrets, data protection, and so forth. The directive requires that member states include interim relief in their legislation. So this is essentially protection to maintain the status quo until the substantive hearing of a retaliation claim. Member states must provide for full compensation to those who are retaliated against. And what's important to note is that there is a presumption that retaliation was for the report or the public disclosure, and therefore the burden is on the person who has alleged to have retaliated against the reporting person to show that any detriment was on duly justified grounds. And for example, if I refer to some research that I conducted on Irish case law in a 6-year period, 88% of cases were unsuccessful. And one of the reasons for that was the burden was on the worker themselves to show that why they were retaliated against. And that was proving to be very difficult. So this reversal of the presumption, reversal of the burden of proof is a welcome addition to the legislation. And then finally, note that there is under Article 23 the provision that member states have to introduce penalties against individuals who hinder or attempt to hinder reporting, who retaliate against reporting persons, who bring vexatious proceedings against reporting persons, who breach the duty of maintaining the confidentiality of the identity of the reporting person, or there is also an offence or a penalty against reporting persons who make knowingly false reports. Under the expert minutes of the European Commission, it was clear that these penalties could be administrative sanctions as opposed to criminal sanctions. Again, if I refer back to Ireland, they introduced criminal penalties, but research internationally on criminal sanctions has shown that such sanctions have rarely been used. But there is, of course, the possibility now that when they have been introduced into national legislation. And then finally, just note that there is, under Article 24, member states have to ensure that rights and remedies under the directive cannot be waived or limited by any agreement, policy, form or condition of employment, including a pre-dispute arbitration agreement. So there has again been evidence internationally of compromise agreements being used to limit the possibility for reporting persons to blow the whistle. So in these settlement agreements, for example, are meant to be void now under the directive. Okay, so that concludes my really a whistle-stop tour of the EU Whistleblowing Directive. So thank you for your attention.
Thank you, Lauren. A whistle-stop tour of whistleblowing. There are no questions in the question and answer box, which is why I didn't stop you earlier. And so we move on to the next session, but don't go. The next session is on EU lawyers and whistleblowing. And this will take the form of me asking Lauren, and I must say our other presenters, if either of them want to come in and help answer the questions, please do so. But so our audience, and you can see that from the chat box, are made up of lawyers. And so I would like to spend the minutes that I've got now in talking about the impact of what you have just said, the Whistleblowing Directive on lawyers. And it seems to me that there are two impacts. There's the impact that lawyers may advise their clients on whistleblowing, but they also may be subject themselves. And I think I'd like to start on that aspect, Lauren. So let's leave to one side the fact that you may have a client as a whistleblower. There, everything you said applies. But what about a law firm as being subject to this directive so that somebody might whistleblow within the law firm? So can I just make clear with you, first of all, this legislation and all the procedures and proceedings that you have described apply to law firms. Is that right?
Absolutely. So I suppose what is worth first noting is that the directive imposes obligations on legal entities with over 50 members of staff to have whistleblowing channels in their organization. So they may be used by lawyers within a legal firm who come across wrongdoing in their workplace context. And so they may avail of these channels in making their report or disclosure. And that could be about a range of potential issues within the legal firm itself. So it could be, a data protection breach, it could be a health and safety issue, it could be fraud. And therefore they would be entitled to use these channels and raise their concern and avail of the protections under legislation. But they cannot disclose wrongdoing that comes to their attention from the consultation with a client, for example, because there's limitations in respect of legal professional privilege, of course. But they may come across wrongdoing in other contexts within their work that may require them to use the internal channels. Or potentially.
Let's just unpack that a bit. Thank you. That's great. And there is a question I see here from Rocchio Palmero about your presentation, which we'll come to before the end. Let's just settle this, though. So in other words, we're talking about the 50 plus. It will apply to law firms of 50 plus. Are there any exceptions to the 50 plus rule? Is everybody subject to 50 plus, or are there some people who are subject to whistleblowing procedures regardless of how many people work there?
There is, Jonathan. So if, for example, there is a legal entity involved in the provision of financial services, products, the prevention of money laundering and terrorist financing, there's no threshold. Irrespective of the numbers of workers in the organization, they will have to have internal reporting channels.
So let me just get this clear as well. So in other words, law firms are subject to the Whistleblowing Directive. We'll come to reporting on clients separately. That's a whole separate issue, as you have said. So if there was something to do with data protection or what have you, they could have a whistleblower within the law firm. They are subject to the directive. But is what you've just said, if a law firm is subject to the money laundering regulations, and many law firms will be, then the whistleblowing directive applies regardless of the number of employees. Is that your conclusion?
But I'm not familiar with the money laundering directive myself, so I can't say definitively, Jonathan, around whether or not it applies to organizations who are involved in the prevention of money laundering, terrorist financing. So I'm not aware of what the full scope of that is.
Yes, so I just say to our audience, I'm not aware of this having been tested anywhere, but it seems to me from what you've said, and I'm not tying you down to any answer, that if the law firm is subject to the money laundering regulations, they may be subject to the whistleblowing directive, regardless of the numbers within them. So just for people to be aware of it. But thank you. That seems to me just a note of caution. And if any other of our speakers have anything to say about that, they can do so. Just to move on to the next question. So whistleblowing on clients. Now, lawyers know very well that if we continue with the money laundering theme, lawyers are required to whistleblow on their clients in relation to money laundering. That is settled in the money laundering directives. And as we know, suspicious transaction reports is part of the European directives. But apart from money laundering, so that is a complete exception, which continues regardless of the whistleblowing directive. Apart from money laundering, there is an exception, is there not, in the Whistleblowing Act, which protects lawyer-client confidentiality. So leaving money laundering aside, where there are special rules on whistleblowing, within the whistleblowing directive, there is no requirement to whistleblow on your client because lawyer-client confidentiality is an exception. Is that correct?
That is correct, Jonathan. So, of course, in the context of a reporting person coming to a lawyer to seek advice, they may disclose information about a serious breach. But a lawyer is confined by legal professional privilege in disclosing that information further. And we see this in recitals 26 and 27 of the directive, and also under Article 3.3 of the directive itself. So essentially, where legal professional privilege applies to the relationship between the lawyer and client, then they will not be able to report that information further and seek to avail of the protections under the directive.
Right, good. And I suppose the last question which I would put on this particular aspect, and then we'll come to the questions in the, there are 2 questions now in the question and answer box for you, is to do with the kind of whistleblowing which might happen in law firms, because although you've talked about something relating to data protection, I assume most of the whistleblowing will actually be a whistleblower to the regulator of the law firm, in the sense that if some ethical or professional rules have been broken by the lawyer, the whistleblower, whoever it might be, somebody in the accounts department, somebody in the IT department, who do we know, another lawyer, will whistleblow to the regulator. And again, this is just, it really seems to me, it's really for our audience to note that therefore the whistleblowing might be to the regulator. Maybe there's nothing for you to answer there. It just seems to me that's the likely path of whistleblowing in a law firm.
It very much depends. As you know, for example, under the Irish legislation, the Legal Services Regulatory Authority is a competent authority under the legislation, and therefore an external disclosure can be made to the LSRA if the disclosure falls within their remit. So it's the nature of the disclosure itself who determines which prescribed person, or we call them prescribed person, but competent authority, that the disclosure can be made to. So again, that will depend on the national legislation about who is designated as the competent authorities, and so it will be very much fall down on a case-by-case basis. But you're absolutely right, it may be a breach of something that falls within the powers of the legal regulator. But I also would like to maybe emphasize that maybe if I can make a point in respect of the role that lawyers may be playing in a whistleblowing process, is that lawyers may be, for example, receiving disclosures, or I call them disclosures, that's the terminology that we use in Ireland, but reports of breaches. They may be receiving information from a client who wishes to make a report, and maybe requiring the lawyer to assist them in making the report. Or they may be approached in the context of the reporting person alleging that they have been retaliated against. Or further, they may be asked to carry out or assist in an investigation, for example. Or you could be on either sides of the coin, the reporting person or potentially the employer themselves. So it's important, I think, for lawyers to be conscious of the fact that the role that they can play may arise in a range of different roles, essentially, a range of different forms. I just wanted to make that point.
No, that's extremely important and very useful. Quickly, the question. So Rocchio Palmero says that there's one doubt: if the report is anonymous, how can the company know that the reporter is protected, for example, from a dismissal?
I absolutely agree. It can be very difficult for an organization to protect or essentially impossible to protect an individual from retaliation if they don't know who the reporting person is. But of course, the culture of any organization should be that we don't retaliate against anybody for raising concerns. But it's important that organizations have it within their procedures, in their written procedures, that they are encouraging reporting persons to speak up in an identified way with a commitment to protect their identity, but of course with the various exceptions within the directive itself. But by encouraging individuals to speak up with their identity known, and with a commitment to protecting their identity, that should hopefully send a message to individuals that they will not be retaliated against for speaking up. And because clearly it's much more difficult to investigate a disclosure that's been made anonymously, and of course to protect somebody who has made an anonymous disclosure. But if we create a culture in an organization that, well, if you speak up about wrongdoing, you will be protected. And I think as an organization, it needs to question why they may be receiving large numbers of anonymous disclosures, if that is the case. And again, we need to send out a message that if you report, you will be protected, and encourage individuals to put their names to these reports.
Very good, thank you. There's a final question from Giovanni Di Salvo. I'm not sure I fully understand it, and so if neither you nor I fully get it, we can ask Giovanni to rephrase it, but I'll read it to you. Giovanni says, I assume there have been comparative studies on the law of privacy. It would be appropriate to know your opinion and thus evaluate the actions to be taken. I don't know whether you're able to comment on it, or you'd like Giovanni to make it clearer.
Maybe if he could
Giovanni, make your question a little clearer, and we can ask it later under the question and answers if we understand exactly what it is that you want us to do. Very good. Lauren, please unshare your slides, because yes, thank you. That's great. We move to the next session, and we're still more or less within our timetable. Our next session is successful strategies in whistleblower casework. And our speaker is Mary Inman, who is a partner at Constantine Cannon in both their London and San Francisco offices, where she heads the firm's international whistleblower practice. She specializes in representing whistleblowers worldwide under the US and Canadian Whistleblower Reward Program. She's a regular commentator on whistleblower matters for the Financial Times, the BBC, New York Times, Wall Street Journal, Reuters, and Newsweek. We're lucky to have her here today, and she's had some very well-known cases. Mary, over to you.
Thank you so much, Jonathan. I really want to thank the European Lawyers Foundation for having me today, and to Mark Worth in particular for recommending that I come and speak. So it's an honor to speak with you all today. Let me try and share my slides. Just a moment, please. Okay. All right.
Yeah, that's right. No problem. They'll come, I'm sure.
Yeah. Trying to get to the right screen.
Oh, yes, that's always difficult.
Hold tight. Sorry, I'm not getting.
If you send them through to us, Mary, we can show them if you prefer.
I've sent them to you, Jonathan.
Ah, right. Okay. Thank you. Sorry, because I've
Sorry.
been talking.
Let me see here. Let me try one more time.
No, we.
Just a moment. I'm getting there. Oops.
Right.
1 second. I think we're going to be ready this time, Jonathan.
Great.
Can folks see it now? Can you see it?
No, not yet.
Darn it.
Aha.
Okay.
Yes. Now
Okay.
we see it.
Let's get it
But
in
it looks like
slide.
your Zoom connection rather than your slides.
There we
actually.
go.
There we
Got it?
go.
Okay,
Yes.
sorry everyone. Okay, thanks for bearing with me. All right, so I'm here today to talk to you a little bit about successful whistleblower case strategies. So basically talking a little bit about the types of litigation that whistleblowers can bring and that in fact employers can bring against whistleblowers. Before we even get into the ideas about the lawsuits and the litigious nature, I wanted to start with some real practical advice, which is that it's always best if you listen to whistleblowers first, so that we don't have to get into a litigious posture. So the first bit of practical advice I would give is to really challenge the biases that we have. We almost have a medieval concept and approach to whistleblowers. We tend to shoot the messenger. So I wanted to sort of challenge people's notions of the kind of biases that we have. If you just look at the headlines, there seems to be a corporate playbook that we viscerally, almost in a knee-jerk fashion, try to shoot the messenger as a way to divert attention from the message. If you look at the Me Too movement with Weinstein, or even the Theranos whistleblower, Wirecard, Enron, Danske Bank, there typically is an effort to try and have a smear campaign against the whistleblower. And I really want to encourage people to examine, why do we do that? Because I think we really need to reimagine who whistleblowers are. But I don't want to start with why we have this approach and sort of what we see. Part of the reason that we try that companies, I think, in a knee-jerk fashion tend to do this is because it has the impact of having a chilling effect on future whistleblowers. So we, in effect, are hardwired to try and stop people who dissent. And so it really behooves an organization to challenge themselves to reimagine who whistleblowers are and who they can be, because they are actually sometimes not are they not disloyal employees, sometimes they can be some of your most loyal employees. They're the people who have the temerity to speak up about wrongdoing when often it is easier to just be quiet. The other myth about whistleblowers that I'd like to challenge is a notion that they actually even know that they're whistleblowers. A lot of my clients, I've been representing whistleblowers for 25 years. A lot of my clients actually are just doing their job. If your job is to be the head of internal audit, and you uncover a problem that will have a really negative effect on your next quarterly earnings report if you're a publicly traded company, and then your leadership tells you to bury those results and you refuse to do that, you are frequently dubbed a whistleblower. So I think it's really important to understand that a lot of people and a lot of my clients don't even consciously consider themselves whistleblowers. They really think they're just doing their job. So I think it's really important to think about why do we do this? It's something that we do in our personal lives as well, as when someone confronts you with something that you may have done wrong or you could have done better. Our reaction is to get in a defensive crouch. So I really want to challenge people to think about not doing that and sort of seeing why we do it and how we could maybe take a different approach. So we'll talk in a minute a little bit about how this is represented in terms of a lot of people are, the way you take adverse action is to demote people, to blacklist people. There's some really interesting research that basically suggests that women whistleblowers are actually treated worse in retaliatory contexts. They suffer retaliation more greatly than men do. I know that Lauren in her presentation was referring to the fact that it can be very difficult to succeed for whistleblowers in the employment tribunals and other cases. But I like to give as an example of this notion of how people think about whistleblowers to remember a story about Jess Staley, who's the former CEO of Barclays Bank in the UK. In the UK, there was a program in the wake of the financial crisis called the Senior Managers Regime that put a requirement very similar to the EU directive on financial services institutions in the UK, that they had to have an internal reporting mechanism that allowed whistleblowers to report anonymously. And one of the first, so Barclays hired some gold-plated, really terrific vendors to put in a state-of-the-art internal reporting system, had training for everyone about how to facilitate anonymous reports. And one of the first reports across the bow was one of cronyism directed at Jess Staley. His response, despite all this training, his first response was to figure out who the whistleblower was, despite the fact that you should be allowed to report anonymously. When he was told that he can't do that, he still doubled down and he ignored the advice. He actually went to the complaint came through the US Postal Service. And so the company basically asked the postal inspectors to try and figure out where the postmark came from. So really doubled down on this notion. And I think this is just something to show that he was ultimately fined about £600,000 by the Financial Conduct Authority in the UK for this behavior. The bank itself was not fined, which I think is unfortunate, because I think it really is important with such a flagrant breach of the rules that the bank itself should have been fined by the authorities. Although in the United States, the New York State regulatory agency actually fined the bank $13 million for this behavior. So it just goes to show how ingrained this kind of approach is. It's also really important to think about what happens to whistleblowers. We know the term now as a result of the Me Too movement. I think about gaslighting. A lot of whistleblowers, because of the way they are treated, they're ostracized, they're cut off from their employers, they're made to feel like they're the only one who feels this way, that they start to doubt themselves. That there's some serious research that shows that whistleblowers suffer severe psychosocial impacts from whistleblowing, from being cut off from their coworkers. The New England Journal of Medicine did a study of pharmaceutical whistleblowers that revealed their higher incidences of alcoholism and divorce, and other depression and other mental health impacts that are associated with it. So again, this is this medieval concept that we treat whistleblowers as if they're radioactive, and that by retaliating against them, we send a signal to other future whistleblowers that this is what will happen to you if you speak up. So this is the sort of parade of horribles that I wanted to put in front of people to explain why it is really important, just practically, as companies, that we not revert to this behavior, and that we actually create an environment where whistleblowers can be heard. So I'd love to have us reimagine whistleblowers. One way to think about them, and this is not my term, this is a term that a social behavioral scientist in the UK came up with, is that whistleblowers should be seen as forward indicators of risk. That they are basically your best risk management tool, because their job is to serve as the canaries in the coal mine, to warn you before the noxious fumes overtake us. There's actually been some really terrific research that actually supports this, that whistleblowers are actually good for the bottom line. So the studies have shown, and I'll point you to some research by professors in graduate business school programs at GWU and the University of Utah in the US, that basically showed that companies, they were given access to the data set from the the world's largest provider of internal reporting mechanisms, a company called Navex Global. These professors were given those data sets, and they were able to deduce that companies that have internal reporting mechanisms that are ringing off the hook, that are active, where people feel safe to report, are actually more profitable than companies whose whistleblower hotlines are silent. It kind of seems counterintuitive, right? If you think that the hotlines are silent, then you think, well, maybe there aren't any problems. And what the research is showing that it's the opposite, that when whistleblowers have an opportunity to be those forward indicators of risk, these risk management tools, they're able to help companies to correct course and change some of the behaviors before they become metastasized into becoming the next sort of big scandal. So I really love this research and love to point it to people, because I think a lot of organizations look at their compliance office and as sort of cost centers for the company. And I think it's really important to really think about the fact that they can be good for the bottom line, that compliance officers and like whistleblowers are people who are trying to tell the company how to stay within the bounds of the law. So that was a little bit of my practical advice. And I just wanted to end this segment on some practical advice about some steps you can do to encourage whistleblowers. We do end of year employment evaluations of employees. You could include, and that's what employees measure themselves against. You could include something in there about the ability to alert and report wrongdoing. That could be something that you value. A lot of whistleblowers choose not to actually report internally because it can be too dangerous for the reasons I just described in terms of the retaliation. So it can be really helpful to do exit interviews. A lot of people leave rather than report. So that's another way to do it. You can do training. A lot of us don't actually know how to speak up or to listen up. It can be difficult, and it's something that we get in our defensive crouch, and maybe we need to do some training to learn how to be better listeners, or training on how to speak up appropriately. Bottom line is I think we need to start normalizing whistleblowing and not, turn whistleblowers into villains, and create an environment where mistakes are not demonized, but instead are celebrated, that, we're in a place of a growth mindset. So that is just the practical advice that I had. But moving on to the types of claims, legal claims that whistleblowers can bring against employers if you're not listening up. The biggest claim that whistleblowers can bring is a claim of retaliation. Lauren touched on this a little bit, but retaliation really can consist of detriments or adverse employment actions that an employer can take against someone who speaks up. So under the EU directive, as Lauren mentioned, there are protections for whistleblowers. And in fact, as she also mentioned, there is a reversal of the burden of proof, which has been really a powerful and very forward-looking approach. In both the UK and the United States, for instance, we do not have these reversals of the burden of proof. And so it has really made it a lot easier for whistleblowers to bring cases and succeed, despite those odds that Lauren had said in the US and in the UK. It's very difficult. I think in the UK and the employment tribunal, around 13% of whistleblowers succeed. I think similar percentages below 20% in the United States as well. And part of that is because it's very difficult for the whistleblowers often to surpass the burden of proof and prove that they were fired because of their whistleblowing, not because of some other pretextual reason. So it is important, and it has been a real game changer. I think we're going to see a lot more successful cases of retaliation that whistleblowers can bring. So it's certainly a bigger risk to employers. Among the types of retaliation that are prohibited are the obvious ones that you'd imagine, like layoff, firing, demotion, transfer of duties, and also blacklisting. So it can often be that it's not just that you as the employer takes action by firing an employee who spoke up. It can also be that you tell other future employers when they call for recommendations, or just if you're in the industry, that is also prohibited, which is an expansion and really important to note. And then, as Lauren also mentioned, one of the conditions for receiving the protection of retaliation is obviously you need to believe that the matters that you are reporting are true. So there are, you can't bring frivolous or malicious claims. You have to have a basis in fact. And also, as Lauren mentioned, the directive has been very good in expanding the types of categories of people who are covered and could receive these protections beyond just traditional workers, to go to shareholders, contractors, volunteers, trainees, and even the colleagues and relatives of whistleblowers. So that is one type of claim whistleblowers can bring. The other type of claim whistleblowers can bring is probably a little less known. I'm not going to spend a lot of time on it, but it is the area that I specialize in, which is that whistleblowers in Europe actually can bring tips to authorities in both the United States and Canada, and receive rewards for doing so. So here I've got these two slides show the 6 programs that exist in the United States. And so in the SEC in particular, our securities regulator, last year, 20% of the whistleblowers who received rewards from the SEC were from overseas. The United Kingdom, Canada, Australia, Germany are some of the largest the countries that contribute the most tips to the SEC program outside the United States. So when you're dealing with multinational corporations or companies that are publicly listed on our stock exchanges, there is extraterritorial reach. So it is an additional risk that if you're not listening to your whistleblowers internally, there's a risk that they can go to the government agencies, and it's not just those agencies in Europe. It's actually, depending on the facts, it could potentially be an agency in the US or Canada. In Canada, there's the Ontario Securities Commission has a program that's very similar to the SEC's program. They also have a program for offshore tax evasion in the Canada Revenue Agency. So that's just another potential risk. Because we're talking about legal claims, I think it's important to distinguish the types of claims that employers tend to bring against whistleblowers. We've seen claims by employers for employees taking documents. So they bring claims against whistleblowers for theft of documents. They bring claims for trade secret violations. One of my clients happens to be Tyler Schultz, who's one of the Theranos whistleblowers who exposed Elizabeth Holmes. And he ended up having to incur over $400,000 in attorney's fees to defend against a claim by Theranos that he had breached his confidentiality agreement that he had signed, and upon employment, he famously said that fraud is not a trade secret. And he ultimately prevailed, but not without incurring $400,000 in attorney's fees first. So there are some very strong measures that companies often take against whistleblowers, including, as I mentioned, and people are very familiar with, breaches of NDAs, and also bringing claims of defamation if whistleblowers go to the media. What's interesting is that there is now a proposed directive in the EU for anti-SLAPP legislation, a directive to stop strategic litigation against public participation. So that is something that hopefully can push back against some of these tactics that are often used abusively. So that's sort of a little bit of the state of play in terms of the types of claims that whistleblowers bring and the types of claims that companies bring against whistleblowers. There are other risks that are posed by not heeding whistleblowers. Under the EU directive, there's clearly signposts. You can report internally. Under certain circumstances, you can go external to the regulator and also go to the media. Those risks have gotten larger and larger as folks have seen from the various papers with the ICIJ that there have been enormous dumps of information on reporting and journalistic outlets that have given us the Paradise Papers, Pandora Papers, Panama Papers, and interestingly, the Panama Papers whistleblower who came out of the Mossack Fonseca law firm was recently interviewed by the journalists at Süddeutsche Zeitung who broke the story, and that person still remains anonymous to this day. There are channels by many journalistic outlets, including not just ICIJ, the International Consortium of Investigative Journalists, who have methods and ways for whistleblowers to provide them with information. Even now in the Middle East and Northern Africa, a group called the Arab Reporters for Investigative Journalism, they also have one for Arabic-speaking peoples to report. The other risks are that the more prominent whistleblowers are, they have an impact. So we see whistleblowers like Frances Haugen at Facebook, a guy named Mark McGann at Uber. They are having the impact of actually encouraging other whistleblowers to come forward. So that risk, it's almost like a magnet effect. And of course, we can see that a lot of people, if they don't get in traditional media, can use social media and other things. I'm almost at my endpoint. The other avenues that whistleblowers have, again, if you're not listening to them internally, they have increasing number of outlets to go to externally. There are a number of terrific NGOs and whistleblower charities that also seek to protect and support whistleblowers. Mark Worth, who's with us and will be speaking next, has the European Center for Whistleblower Rights. There's groups called the Signals Network. There's country-specific ones, like in the UK, there's Whistleblowers UK and Protect. There's a global one called the Whistleblowing International Network, and there's a new one in Canada called the Integrity Sanctuary that's trying to provide safe houses and safe housing for whistleblowers who are under threat for their personal safety. So they're increasing opportunities. I think one that I think is particularly interesting comes out of the UK. There's a climate activist organization called Extinction Rebellion. They actually have a site, a portion of their website that they seek and to ask for whistleblowers to come forward. It's called truthteller.life. They allow whistleblowers to bring information about environmental greenwashing and other effects. They actually, this is a picture from what they did in April of this year outside Shell's headquarters. They actually, they encouraged people to come, and they actually were outside the headquarters with the names of all of the employees inside, encouraging them to speak up. So there are a lot of people who are organizations who aren't just sitting and waiting for whistleblowers to come to them. There's some actively recruiting them. And finally, I think the other risk to employers is that there are now a lot more ways. The technology for internal reporting mechanisms has increased. That's good news in terms of it helps, I think, more people bring information internally. And some of them include, for instance, something called a Go Together feature. There's a company called Vault that actually takes the Me Too concept and allows whistleblowers to get over the hurdle of sometimes it's difficult to be the lone whistleblower, but it's easier when you're in solidarity with another whistleblower. So they actually have a feature that allows whistleblowers to report, but put their report in a pending status and say that it will not be released. I'm only going to report if someone else makes the same report against a similar person. So there's technology that's actually having an impact of actually increasing the likelihood of reports. So I actually think that's good news in terms of increasing the chances that people will report internally effectively. So that is what I have. Hopefully I'm within my time.
You are well within your time. We have 5 minutes. There are no questions, but I have some questions for you. So maybe we can tease them out. I mean, I saw you mention the Panama and Paradise Papers, for instance. These are very well known to lawyers, of course. I mean, because Fonseca was a law firm, and there have been big consequences for lawyers from that leak in terms of accusations that lawyers are enabling their clients to do things which they shouldn't do. But let's just speak about that leak. I mean, you called it a whistleblowing, but of course, the interesting thing about this leak is it's a leak of client secrets, and is, if it was a lawyer who leaked it, we don't know who leaked it, you told us, then it's breach of lawyer-client confidentiality. This kind of leak under the European Whistleblowing Directive, what are the consequences? I mean, given the fact that a lawyer should not be leaking client secrets, but if a lawyer has leaked these client secrets, obviously there are regulatory consequences if the lawyer is discovered. But if the lawyer is disciplined by the bar, would that then be in breach of the European directive because there's been retaliation? If the law firm reports the whistleblower, as you call the person, to the bar and they are disciplined, is that in breach of the whistleblower directive?
That's a question I really don't know the answer to that. I know Lauren may have a stronger hold on
don't worry, I'm not trying to catch you out. Just any comments you may have in it. I mean, and if you have no comments,
well, no, I do. What I think is really interesting, and this gets to the power of anonymity, right? Is that when you're allowed to report anonymously, then there's inherent in that some protections for people. What's interesting here with this whistleblower, when he was, or she or they, we don't know the gender, when they were interviewed recently, they basically said their anonymity is what allowed them to live a life without being, put in harm's way and other things. It's interesting also, the whistleblower said that in Germany, they were expecting a payment. We've now seen that while the Americans and the Canadians have official programs to pay whistleblowers, Germany has been known and has a reputation of doing it unofficially. So that again is just another risk of other external forces that can attract people to speak out. I'm actually just going to change my camera so that you can see me. For some reason I'm frozen, but I will.
We can hear you perfectly. Very interesting. Thank you. I have just one more question since we have a couple of minutes. I wonder if you could say more, and again, Lauren, I'm happy anybody to chip in, about the reversal of the burden of proof, because this is also something which strikes lawyers. It's not usual, and often there are difficulties with reversing the burden of proof because you might have to try to prove a negative. In what circumstances is the burden of proof reversed? This is if I bring a case, I think you mentioned one, that I have been dismissed because I've been a whistleblower. Now the employer has to prove that I was not dismissed because of whistleblowing, but for some other reason. Is that correct?
That's right. That's right. And the power of that is that it used to be, or at least it certainly still is in the United States and in the UK, where the burden still sits with the whistleblower, is that they're often pretextual reasons that are given, right? So there's a famous case in the UK of a whistleblower by the name of John Banerjee from the Royal Bank of Canada. He was a trader on one of their FX desks or something, and he was chronically late his whole career. That was always overlooked until he spoke up. And then as soon as he spoke up, then he's being terminated for being chronically late. So clearly that's pretextual, right? But that often is very difficult to prove, right? Because people are attracted to saying, well, he's chronically late. So under the EU directive, if the same fact pattern would exist, he would just have to say, I spoke up successfully. I had, I did it as a basis of, I was truthful and why I spoke up about the disclosure. And then the burden shifts to the Royal Bank of Canada to say, this was because of whistleblowing. I mean, this wasn't because of whistleblowing, this is because of all of these other reasons. So I do think it's going to have a big impact because it's hard for an employer. I mean, a lot of, the best case for a lot of my clients is a lot of them have, terrific performance reviews year after year after year. And all of a sudden, as soon as they speak up, they're not a team player. That's what they start to hear. Right. So the facts, those facts are more beneficial when it's put to the employer to have to say, I had another reason that was legit.
Interesting. Thank you.
This is an extremely important point that you make, Jonathan and Mary and Lauren, and it gives rise to what is called reason shopping. Everybody's late for work, everybody makes mistakes, and these things become part of your record. So you need a very enlightened judge or other sort of public official to see through that and say, well, if this person was so terrible, why didn't you fire them 5 years ago or 10 years ago? And you have to have a really open-minded judge to call out the employer. And it's been very difficult to find such kind of wise judges to make these decisions properly.
Excellent. Good contribution and a good introduction to you. First, thank you very much, Mary. Thank you. Very, very excellent presentation. We now come on to our next presentation and the last substantive presentation, which is to do with limiting risks to whistleblowers and maximizing the positive impact of cases. And our speaker is Mark Worth, who has just spoken now, who's Executive Director of the European Centre for Whistleblower Rights. Mark is much more than that. He's also the founder of Whistleblowing International, of the Southeast Europe Coalition on Whistleblower Protection, and the Whistleblower Programme at Transparency International. He's an international fellow with the Whistleblower Rights law firm of Cohn and Colapinto in Washington, D.C. He was a member of the United Nations Organization on Drugs, what was the Drugs and Corruption, on whistleblower, and a founding board member of the Platform to Protect Whistleblowers in Africa. I think I've said enough to say that he has for decades been involved with whistleblowing. He's trained hundreds of public officials, attorneys, activists, journalists, and he began his career as a journalist, as a staff writer for the New York Times. Very good. Mark, over to you, please.
Thank you, Jonathan, very much. It's great to see everybody today. Thank you for hanging in with us all morning. I'm going to be talking about our experiences working on actual whistleblower cases, as Mary did and Lauren. And I hope that this very brief presentation will be helpful for employment lawyers, labor lawyers, and even criminal lawyers who may have whistleblowers who are in criminal distress. The rapid and steady growth in the number of countries with whistleblower protection laws in Europe and elsewhere has generated what I call the retaliation industry. And this should not be very surprising to anybody. This industry is getting smarter and better resourced every year. Law firms that are becoming quite expert. Law firms are becoming expert at finding and exploiting the many gaps and gray areas in whistleblower laws. And you need to know that these laws are not as clear as you think. There are many gray areas, as we've discussed today, and we will discuss in the next few minutes. And we also need to know that some lawyers play for both sides. Sometimes a law firm represents an employer, sometimes they represent an employee, and they use this intelligence to win cases on behalf of employers. So playing defense is just as important, or perhaps more important, than playing offense. We talk about whistleblowers as being an offensive thing, but playing defense is very important. So you can limit the risks to your clients by understanding what you're up against in these cases. This is really an open secret in the whistleblower protection community, that most laws don't really have real protection mechanisms. And let me explain. Only a few countries in the world actually have an administrative agency that can order an employer to reinstate and compensate a victimized whistleblower. Public agencies such as the Ombudsman Office or Anti-Corruption Agency can only recommend remedies and relief. And because of the delicate and combative nature of whistleblower cases, mediation is rarely a realistic option. So many cases wind up in court, as we've talked about. Unfortunately, a vast majority of judges are not trained or knowledgeable enough about whistleblower laws, or they are outright skeptical or even hostile toward whistleblowers. So going to court is high risk and highly costly. You can limit the risks to your clients by fully understanding the weaknesses in your country's whistleblower protection laws, if it even has such a law. This is a statistic that needs to be seen more broadly. This is based on a 2021 study that I worked on by the International Bar Association and the Government Accountability Project in Washington, of 37 countries all over the world with the whistleblower law. 79% of people lose. Now, we don't know what the percentage should be, but it should be a heck of a lot lower than 79%. Mary and I think Lauren talked about the very low percentage in the UK, which has had a law for 24 years. It does not work. If you go to court, there's a tremendous chance you're going to lose. Quick example, in Denmark, which always ranks very high in all the anti-corruption ratings, earlier this year, a woman lost her case at the Supreme Court in Denmark. She was a public servant in the city of Copenhagen, had been there for decades. She was in her 60s. She reported that people were not receiving their benefits, their social benefits for disability properly. She told the newspaper about this because she was ignored internally. And she was convicted of releasing confidential information. She was sentenced to 10 days in jail, but it was a suspended sentence. But the Supreme Court upheld the criminal conviction against this public servant because it ruled it was not necessary for her to blow the whistle in the way that she did. And this is, can you imagine your client is fired because a court rules that it was not necessary? Well, witnesses should not have to prove that it was necessary to report a crime. That's what witnesses do. So Germany's draft law includes this. The directive does not ban countries from requiring whistleblowers to prove it was necessary to make a report. Imagine you are in this position of having to decide, do I really have to call the police? Do I really have to call the regulator? This is a tremendous deterrent effect. So we're very shocked by the case that happened in Denmark. You can read about it. I've written about it. So you can limit the risks to your clients by assessing the likelihood whether he or she will get a fair shot in court or other tribunal. Another shocking statistic, in our research and work training public officials, 90% of them are either, they say they're either too afraid or do not know how to handle a whistleblower case. These are public officials who implement and enforce whistleblower laws. Many of them have told us that they are worried about being retaliated against themselves by aligning themselves with whistleblowers, essentially makes them a whistleblower too. Just last week in a country in Europe, a public official told me she was threatened with being disciplined just because she held a meeting about whistleblower protection. And the only reason she wasn't disciplined is because at the time she was pregnant and her manager thought it would be unfair to dismiss a pregnant woman. Otherwise, she would have been disciplined or even fired just for having an internal meeting about whistleblower protection. So again, this happened in Europe. So you can limit the risks to your client by assessing the level of courage that public officials have in your country to oversee the whistleblower system. If you don't see a lot of courage on the part of the judges or the public officials who are in charge of these frameworks, you should be careful. Our motto is called what we call quiet justice. Blow the whistle, but don't become a whistleblower, a public whistleblower. And this is my inescapable conclusion after working with whistleblowers for 36 years. And this is how we work today. There is simply no reason for 99% of people to go public with their name. We strongly discourage this, and we have outright refused to go along with the wishes of people who want to become public whistleblowers, going on television, writing books, and trying to get deals with Netflix. You would be surprised how many people have become ensorcelled by the idea of becoming the next Edward Snowden. It almost always winds up badly for them, bad for their career, bad for their legal case. Sometimes going public can be advantageous, or in the case of the Panama Papers whistleblower or whistleblowers, doing it anonymously. We make investigations and we don't even say that there was a whistleblower because the risks are just too high that he or she will be identified and targeted. So you can limit the risks to your clients by making the right decision on this issue. Don't become a professional whistleblower. More and more, we are seeing people listing themselves as being whistleblower on their LinkedIn profile and on online platforms as being their job. Of course, whistleblowing is not a job. It's an action that people take and then hopefully move on from without it becoming their identity. We are encouraging people to take the word whistleblower down from their LinkedIn profile, and many of them are taking our advice, which we're very happy about. You can limit the risks to your clients by discouraging them from advertising themselves as a professional whistleblower. We like to think that most people like and support whistleblowers, but we are not quite there yet as a society and as a civilization to have this broad public acceptance. And it might be a long time before we ever get there, if ever. You can limit the risks to your client by understanding that whistleblowers always will have doubters and even enemies. And you can manage these risks by picking your battles and recognizing when the battle will not end well. So this might all sound like a downer. I don't mean to be a downer, but we work on cases every day. We see the realities on the ground. But the fact remains that whistleblowers are making great contributions to public integrity. The media is reporting on cases more responsibly and with less exploitation. More whistleblower protection offices, agencies, and NGOs are being established. And there certainly are signs that a whistleblower culture is blossoming in Europe and worldwide. But like many types of witnesses, like any type of witness, whistleblowers see and report problems that need to be fixed. And this is where we devote most of our efforts, what I call whistleblowing for change. My good friend Tom Devine at the Government Accountability Project in Washington, D.C. has helped more than 7,000 whistleblowers since the 1970s, and he has been largely successful because of what he calls building a circle of support. Even lawyers need to have support from other stakeholders. You cannot do it alone. Most cases, especially the big cases, cannot have a good outcome unless you have strong, effective, and credible allies in place who are geared up for a potentially long struggle. So who was part of this circle of support? Journalists are not supposed to take sides, but you can get them on your side if you understand how they think and how they work. Every journalist loves a big scoop, and most of them have big egos. It's just a fact. You can use this to your advantage. If you have a story, do your homework, go step by step, find the right journalist, the right media outlet, establish a good connection with them, and offer them an exclusive story. give them complete and reliable information, and a big story can get officials to leap into action. But be careful how you deal with the media. Law enforcement and other investigative agencies often get stuck in the middle of a whistleblower case. And like we said earlier, 90% of public officials who work on cases are too afraid or don't know how to deal with the cases. Investigators are also under political pressure. So great care must be taken when referring information or evidence to investigative agencies. A mutually beneficial relationship can be formed, and good evidence obviously can help officials in their enforcement and prosecution work, what we call a cake mix in a box. All they have to do is add water and the case falls right into their hands, thanks to the whistleblower. At the same time, successful enforcement actions and prosecutions can help validate your client, very important, especially in high-profile cases that get into the media. Use your client. They're on your team. While protecting your client from all risks and threats is the most important part of your job as a lawyer, your client is still at the center of the case. They are more than just a client, however. They have provided you with an opportunity to use your position and your skills to achieve justice, to right a wrong, to uphold the free speech rights of citizens, which is what whistleblowing is, and to utilize the law and the legal profession to further their original purposes and highest ideals. Your client is an ally in this, and you should make most of the information that they have provided to you and honor the risks that they have taken. They have taken a chance on you, and in many ways, they are your partner. Mary mentioned NGOs. Advocacy organizations can help to amplify the importance of your case if it becomes public. More and more of them, such as Global Witness, Amnesty International, and Greenpeace, are working with whistleblowers and other vulnerable witnesses to expose crime, corruption, and public health dangers. These groups have good access to the media, coalitions among themselves, courage, resources, expert level issue knowledge, political savvy, and a high level of trust among the public, which can help you in your cases. They can be the X factor that can lead to better and more sustained results, and they can turn your case into a cause, which will resonate more with the public. And finally, this is your chance to carve out a new area of practice in your law firm. A great whistleblower rights attorney can stand out in their field and build a public reputation as a person with integrity, courage, and concern for the public. People respect and admire attorneys who work for the public interest. Plain and simple, people love attorneys with integrity and courage. Names like Stephen Cohn, Tom Devine, William Bordone, who I have had the privilege to work with personally. Once you establish yourself as an expert in this new and specialized field, you will gain more clients, grow your practice, and win more cases. From here, a boutique law practice can be established. You can become one of the few people who are really, really expert in the field of whistleblower protection at a time when it's needed most. The timing for this is perfect because there are still so few attorneys who are true experts in whistleblower rights. So that is the whistle stop on some of the soft skills that are required, whether you're a lawyer in the civil world or the criminal world. And thank you very much for being with us and paying attention with us today. Thank you.
Thank you so much, Mark. Excellent, very interesting. Please unshare your slides. Whilst you've been talking, although I said everything must be in the question and answers, and there is a question, Kristalia Sturu said that the directive is absolutely necessary because it's necessary to cultivate an essence in society in favor of whistleblowing. But there is a question from Patrizia Piemontese, who says it's a bit the same. Don't you think that the cultural identities and the Volksgeist, which is the kind of essence of a community, the culture of a community of each country, could play a big role in a whistleblower's action? And how can an international or a European law prevent and overcome this limitation. National implementation may not be enough. And I suppose, you know, we have societies, we know, name anybody, where the communal is more important than the individual, for instance, and so on. So I don't know if you've any, and I must say, we now throw it open to Lauren and Mary as well. I don't know whether you have any comments on that about the cultural identity and how to overcome that.
Well, I have traveled to dozens and dozens of countries all over the world. I read about cases, I investigate them, I talk to journalists, activists, academics, researchers. We get this question a lot. I don't want to say that a certain country has more of a whistleblower culture than another one. But I wrote an article recently called "Germany Loves Whistleblowers Unless They're German." And where I lived for 15 years, Germany, I would say, does not have a whistleblower culture because they love Edward Snowden and Julian Assange and Bradley or Chelsea Manning. But every public whistleblower in Germany has been crushed, poisoned, harassed, sent into a psychiatric institution, sued, you name it. Other countries just seem to be more open. I don't want to speculate why. People talk about historical factors, religious factors, the role of the media. Is the media diverse, and does it have alternative media? But clearly, even in Europe, we have countries like Switzerland, Germany, Poland, Austria, Spain, big countries that don't have a whistleblower framework, where there's not even a whistleblower status, does not exist as a legal construct. But a country like Moldova, Montenegro, Ireland, other countries are doing a good job at trying to protect. We had the first case in Moldova, where I was last week, where the Supreme Court ruled in favor of a whistleblower. Well, how could that happen in Moldova, but not in Denmark? So I think it's important to understand that there are differences without getting too held up in why the differences are there. But I agree with the person asking the question. Anything can help. An international framework, however, shows that we have a universal agreement, and also through the UN Convention Against Corruption, the OECD Anti-Bribery Convention, some of the great UK laws, the American laws. There's a consensus now from the highest levels of international organizations that whistleblowers have a free speech right to report crime and corruption. And why shouldn't they have that right?
Jonathan, can I jump in just
yes,
quickly? I
yes.
completely agree with Mark, and I would just add that Patricia's question is a good one, because it's actually that was the basis for the reason that the EU Whistleblowing Directive was created, was that it was inspired by a whistleblower by the name of Antoine Deltour, who exposed LuxLeaks, and it was really how he was treated. France at the time did have a whistleblower law, but Luxembourg did not. And so because of the information he was revealing about, I forget the name of the Big Four accounting firm, but that he worked at, you know, he was to be found criminally liable in Luxembourg, whereas he would have been protected in France. So the idea is, of course, to create that floor. So I think it is, even though there are all of these cultural differences, the idea would be to at least have a level set and to have a floor, and which is particularly important when there are gig workers who work across all 27 member states.
Thank you. Then I have a question. There are no other questions, but this follows on from everything all of you have said. So I am a whistleblower. I am whistleblowing against the European Lawyers Foundation. And I come to you as a lawyer. I know, Mark, you're not a lawyer, but you know more than any lawyer knows anyway. I come to you and I say, I'd like to whistleblow. And I've listened to this seminar and I've heard about the terrible penalties, which, you know, the $400,000 worth of costs which the Theranos one had, or the, you know, psychiatric institution that Mark was talking about. I mean, how do you as a lawyer persuade, I mean, Mark dealt with some of this about quiet justice and so on, but, you know, I swim in a small world of legal services. They all know that I all know the same people. I'll be known as a whistleblower. Why should I go ahead? And how do you as a lawyer persuade me that I should go ahead despite the very oppressive things which might happen to me? What would you say to me?
I'll let Lauren jump in too, but I will piggyback on what Mark says. I will dissuade you from doing it, right? My job as a lawyer is not to convince you to blow the whistle. My job as a lawyer is to tell you the parade of horribles that may follow from it. So it's to give you the advice about, so my favorite whistleblower client is someone who's on the cusp of retirement, who has a lovely nest egg. Right? I'm going to give very different advice to that person than I'm going to give to someone at the very beginning of their career in a very tightly held profession. So it's very dependent. And I think it's professional malpractice for a whistleblower attorney not to tell whistleblowers. Remember, whistleblowers come to us when they're in extremis. Right. They have been, it's a very hot moment. They're having, they're obviously sparring with often their supervisors and others. And that is not the best time to make decisions, right? We're not always level-headed. So we work really hard to be what we call whistleblower whisperers, which is to bring the temperature down, to involve their family in the conversation if they're willing to have that happen. If you're the sole breadwinner in a home, in a household, then it's really important to think about what that could mean for you, what blacklisting might mean. So we don't always talk our clients out of it. It's obviously always their decision. But there are plenty of times when you shouldn't blow. The answer is you shouldn't blow the whistle. There can be ways you can blow the whistle anonymously and more safely in certain jurisdictions, the SEC, other places you can do that. But remember that anonymity is only as good as the fact pattern that exists, right? So maybe the regulator won't tell the world that you were the whistleblower, but if only 5 people knew about it and they go to process of elimination, you can be sure your career may be over. So it just really depends.
Understood. Lauren, you want to speak?
Yes, please. So I'd like to make 2 points. First, in respect of the cultural piece, absolutely, legislation is only one part of the jigsaw. But what is welcome with the directive is that it's not only concerned with protection of the reporting person, but is actually obliging organizations to do something about the wrongdoing. So they need to assess it and respond appropriately. And that it was what was missing in a lot of national legislation that did exist up to this point. Was it was always just protect the messenger, but there was nothing about the message. And hopefully that will assist in changing the context to what is being disclosed as opposed to who is disclosing it. And secondly, the point about the advice. If somebody has come to you in your capacity as a lawyer and they want to make a report, this is a really good first step for the individual, because it's often the case where a reporting person has spoken up about wrongdoing in the organization and they haven't raised it correctly. They may have, for example, downloaded data illegally onto a USB and have now used that to try and prove their disclosure. But if a reporting person, somebody who comes to you and wants to blow the whistle, if they've gone to a lawyer, they're going to be much better equipped to ensure that when they do raise their concern, that they are complying with the law, so that if they unfortunately are subsequently retaliated against, they should be in a better position to be able to avail of remedies, legal remedies. So by coming to a lawyer, that is empowering the reporting person to speak up and speak up correctly.
Good. Mark, anything about quiet justice? Have you said everything you want to say? You've got more to say.
Well, I think what Lauren said is absolutely perfect. We do this all the time. We don't want to have to use the law, but it is there as a good backup, and we don't want anyone to violate the law. So we have many cases where we go through step by step to make sure that the law was complied with. A lawyer is essential for that, and we have lawyers who we work with. But I would tell you to give us the evidence, and then you just go back to work. I make a silly analogy. If your neighbor's house is on fire, do you grab a hose or do you call the fire department? So we are the fire department. You don't have to take on the risk. We take on the risks. I get threatened, I get followed, I get chased, I get harassed. We don't want you to have to go through that. So call us, give us the information, and then you've done your job. And then that's the end of it. And then you have to make a personal decision. Do you want to continue working at a place where there's corruption or misconduct? And then the next step that we take is, what's the right thing to do with the information you've given us? If we report that to the regulator or write an article about it, and if that would threaten your career, then we probably wouldn't do that, because you are our partner. Like Mary said, our job is you are our main concern. However, we have a case now which is potentially monstrous, and we're talking with the person about going public. We think the person is a good candidate to be a public whistleblower. We're going very carefully, step by step. And, but like Mary said, every case is different, depends on the factor. If it's a huge case and the person is prepared to go through that experience, we will hold the person's hand and do it responsibly. And Frances Haugen is a great example of that. She was prepared, she is prepared, she's poised, she's amazing, credible. She went to Congress. She's protected now because she's so famous. Nothing's going to happen to her, I hope. And you can do that, but in very rare cases. But if you work at ELF, which is a very small organization, we would advise against you doing something reckless.
I take your advice. Frances Haugen is the Facebook whistleblower. Yes, thank you, thank you. Thank you so much. In the comments, you'll see what extreme praise has been poured on you as the speakers for your very excellent, helpful, and informative presentations. And I can only second that. I shall give, on behalf of all the participants, a round of applause to our three excellent speakers. And thank you very much. Just to remind the participants that if you want a certificate for this training, if you ask your bars, we will send the list of participants to them so they can issue the certificates. Also, to remind you, the wonderful slides which we've seen will be put on the European Lawyers Foundation website in a few days, together with the recording. It just remains for me once more to thank you, the speakers, very much for your wonderful presentations, and to thank you, the audience, as well, for sticking with us and hearing us out. Thank you very much, everybody, and that brings this presentation, this webinar, to an end. Thank you and goodbye.
Thank you.
Bye.